As a real estate agent, you should know how to sell property held by an estate. Whether it's a deceased person or an incapacitated individual, we're going to cover it all today. Sometimes, as we are helping our clients sell property, we find that the property is held in this weird thing called an estate. What the heck is an estate? So an estate is actually the totality of a person's assets. It's everything they own. That's a very general term. In the state of Michigan, we have this thing called the probate court that handles administering estates for people. And generally, when someone can no longer make decisions for themselves or their property because they have either passed away or they've become incapacitated, their estates, all of the things they own, need to be what's called probated. So this is the formal legal process where a court is going to review their estate, review their circumstance, whether they passed away or became incapacitated, and they're going to approve, confirm, appoint a person who can act on behalf of that person that was deceased or incapacitated. So the court is going to determine and decide that this person cannot handle the assets that they own, and then decide on who can do that for them. And that person that they appoint is what we call a personal representative. So now that personal representative is who is going to act on behalf of that estate. And now let's talk about the different kinds of estates we have, because there's more than one, which is a common misconception. So the first type of estate that we can have is a decedent's estate. A decedent's estate occurs when someone passes away, and obviously someone else needs to facilitate sales or management of their property now. Another type of estate is a conservatorship. So a conservatorship is created when someone becomes incapacitated and they need someone to help make big decisions, and usually we're talking about financial decisions. And another type of estate that can be created is a guardianship. A guardianship we see a lot with younger individuals, and that guardianship is focused more on helping people make decisions about their personal well-being and their health. So when we're dealing with real estate and we're dealing with estates and probate, we're really dealing with conservatorships and decedent estates. So we're dealing with people who have passed away and can no longer deed their property. And we're dealing with people who've become incapacitated and can no longer deed out their property. So it's important to understand how title works, so we know why estates get a little bit complicated. So we talk about this thing called a chain of title. And a chain of title is going to link every grantor and grantee to the next. So from Adam to Bonnie, and then Bonnie to Carol. Now, what happens if Bonnie passes away? You can't go from Adam to Bonnie and then magically to Carol. You also can't go Adam to Bonnie and then Ryan, who is Bonnie's second cousin, to Carol, right? You need to have some legal authority to tie those two deeds together. So Bonnie still needs to deed out and eliminate her interest. We've got to keep that chain consistent. So Ryan, if he is the correct person, needs the correct legal documentation to show that he's signing on behalf of Bonnie. So in order for us to understand probate, we really need to take it back a step and make sure that we understand tenancy as well. So a quick reminder, joint tenants with full rights of survivorship, right? That looks like Sally and John as joint tenants with full rights of survivorship. If John passes away, that means that Sally owns the property. So if you have joint tenants with full rights of survivorship and one passes away, the other has full legal title. We don't have to have a probate scenario because title passes from the deceased person directly to Sally, our original person, due to tenancy. Right now, what happens if in that same situation, Sally passes away too? She passes away second. So how are they going to deed that property out? Well, now is when probate comes in, and Sally is going to have an estate opened and have her estate probated. And then her personal representative will need to sell. Not John's. We've already eliminated John's interest. Just the surviving joint tenant has to open up an estate. And then we look at tenants by the entireties, and we know tenants by the entireties works the exact same way. The only difference is the two parties have to be husband and wife, right? So that's going to go the same way if Sally and John are husband and wife. Again, if John passes away, the property will go to Sally. And if later Sally passes away, it'll be Sally's estate that gets probated, not John. Now, in the state of Michigan, tenants in common is actually the presumed tenancy. So if you don't write Sally and John with joint tenants, full rights of survivorship, it's presumed that Sally and John own property as tenants in common. So if Sally passes away, so Sally's interest has to be probated even though John is still alive. And vice versa. If John passes away, John's interest has to be probated and his personal representative has to sign. No interest gets eliminated and passed on to the other. So you could have a scenario where you have Sally's personal rep signing and John's personal rep signing, and you'd have to have both estates probated. Now that we know when we have to get probate involved, the real question is, how does probate work? How do estates work in Michigan? Well, estates work in Michigan based off of this thing we called EPIC. And it's not that exciting. It's really the Estates of Protected Individuals Code. So again, we're talking Michigan compiled laws. So how do we end up with an estate and title? How do we end up with this? Well, first, there has to be something that happens to this person who owns the property. Sally owns the property. She unfortunately passes away, or she becomes incapacitated. And that means you usually end up with a death certificate or some doctor's notes, things like that. Then usually in the state of Michigan, we are going to hire a probate attorney who is going to do all of that work of doing what we call probating the estate. So they're going to help you navigate this probate process. They're going to fill out the paperwork, the court mandated forms. They're going to gather all of the information. This could be super, super complex and involve many interested parties and maybe lenders and creditors and 10 children and 100 properties owned by Sally. Or it could be super, super simple. And maybe Sally has one daughter and one property, and it's just a little bit of paperwork. And then that attorney, or you could do it on your own, but usually people use an attorney, is not only going to fill out all of that paperwork, but they're going to help with any actual court proceedings. You may need to appear in front of a judge and have that judge is actually going to sign off and appoint that person that we refer to as the personal representative. And that personal representative is who can sign on behalf of Sally. So the court is going to issue this thing called letters of authority. Those letters of authority appoint that personal representative. It lists their name on there. So Sally's daughter cannot sign anything on behalf of Sally's estate without those letters of authority. Those letters give them power. Now, whether you have a decedent's estate with a deceased person, or you have a conservatorship with an incapacitated person, either way, the document that you're looking for is called letters of authority. And in both scenarios, the person they're appointing is called the personal representative. When we receive those letters of authority, we do want to be careful. It's going to tell us who can sign on behalf of that estate. It's also going to tell us if there are any restrictions. And what is a restriction? Well, it's something you can't do. So sometimes it will tell us that they can't sell property, or maybe they can't sell the property that incapacitated person is living in. But we don't just want to say, yay, check the box, I got my letters of authority. We want to also read them and make sure that they're not restricted from doing something like selling the property. Now, it's not super uncommon to see restrictions. If you do have some restrictions and those letters of authority say Sally's daughter is the personal representative, but she can't sell property, well, we do have options. What's going to happen is that probate attorney is going to have to go back to probate court and get a specific court order allowing the sale. So the personal representative will get that court order, and then they will be allowed to sell the property. We do need to be careful, because if we have a court order, oftentimes we need to be careful of this thing called an appeals period, which is a time period in which that court order can be appealed. So we have to do what's called observing that appeals period. We've got to wait out that time frame to make sure that no one is going to object to that court order, and then we can rely on it. So I know that I have an estate and title. What do I need to think about when I'm getting my purchase agreement signed and preparing for closing? So first and foremost, we have an entity and title. We need to know who can sign on behalf of this entity. And because it's an estate, whether it's a decedent's estate or a conservatorship, we need to know who the personal representative is. So I must have valid letters of authority. If you don't have letters of authority, you don't have a power to sign. Next, I'm going to look at my actual purchase agreement. Do I have terms that I need to evaluate in the purchase agreement when I'm dealing with an estate? The answer to that is yes, absolutely. What type of deed is my seller comfortable giving? Again, if you have someone who's sitting in front of you ready to sign a purchase agreement, we want to have this conversation. Are you comfortable giving a warranty deed? Have you lived in the property? Are you familiar with the property? Do you feel comfortable giving that warranty deed? Make sure we know that before we sign the purchase agreement promising to give the warranty deed. Next question we want to ask is, what type of owner's policy is being given? Is it with or without standard exceptions? Again, if my client's a personal representative on behalf of an estate, they may not know a lot about the property. They may not be comfortable signing affidavits in lieu of survey or answering certain questions that would be required if we were promising to give an owner's policy without exceptions. So we may need to only offer an owner's policy with exceptions to avoid putting my seller in a position where they're being asked to answer questions that they maybe don't know the answer to. The next thing we want to think about is what social security number or TIN number is going to be used at closing. If you have questions about this when you're dealing with an estate, it's always a good idea to refer to the attorney who's handling that probate estate, but we want our client to be prepared for closing. So we want to make sure that we have this conversation as early as possible. Make sure that the personal representative knows what tax ID number needs to go on that 1099-S at closing. And the last thing we want to think about is making sure that that proceeds check at the time of closing, remember it's an estate selling property, so the proceeds have to go back to the estate. So we want to make sure that they have a bank account for the estate. So when do I think that an estate may be involved in my closing? So if I have a trust in title or I have an LLC in title, which are some other common entities, it's usually really clear because someone had to deed the property into the trust or deed the property into an LLC or a corporation. We can look at the simple vesting deed to see either is it held by a trust or not. Estates are a little bit more tricky because usually people take title and then something happens to them while they own the property. Either they become incapacitated or they pass away, and now their estate holds title. So how do I know How do I know if that circumstance has happened? Well, I want to make sure that I'm asking my clients questions. Is the person standing in front of me trying to list this house? Are they telling me it was their parents' home and their parents passed away? Are they telling me that maybe their parents are incapacitated? If they're giving us any of those clues, we want to ask, do you own the house or did your parents own the house? Is this a probate situation? Is this a deceased individual? Is this a conservatorship? And then we want to ask some questions about where my client is at in the process. Did you already open up an estate in probate court, or have you not even started that yet? This is a very important timeline question. We want to know how long before we can close the property. We don't want to accept a cash offer that wants to close in 15 days, but meanwhile, my client hasn't even opened up a probate estate, and we know that they've got 9 brothers and sisters, and this might get a little messy, right? That's not a good scenario. We don't want to put ourselves in that spot. Anytime you think an estate may be involved, it's highly recommended that you do something like a pre-title search. Most title companies, Legacy Title involved, will be more than happy to do a quick pre-title search. We'll see, oh yes, it looks like there's a probate estate, it's already been opened, there's already letters of authority issued. Or no, we don't see a probate estate has been opened, we don't have letters of authority, this may take a little bit longer to get what we need for closing. You can also ask the attorney who's involved. That attorney will be very familiar with the actual probate estate if they've already found an attorney and the attorney's been working on it. And they should be able to give us a good timeline too about how long they think it will take to continue to get this estate probated and how long it'll take until we have good letters of authority that we can use to close the transaction. Another fun thing we have when we're dealing with estates is this concept of self-serving deeds. Here in the state of Michigan, if a fiduciary, such as a personal representative, deeds the property to themselves. So if Sally's daughter deeds the property to herself and then she tries to sell it, that's actually a self-serving deed. The deed where Sally's daughter acted as a personal representative and deeded it to herself, that's a self-serving deed. And in the state of Michigan, the Land Title Standards 7.11-2 actually tells us that after March 31st, 2000, this deed from the personal representative to themselves is not marketable. That means we can't trust it, we can't rely on it on its face, meaning we need additional documentation to be able to utilize that deed. Now, the good news is Land Title Standards give us 3 options. So we've got 3 things we can get in order to be able to trust this self-serving deed. Number 1, we can get an express court order. So we can get a court order from the probate court allowing this deed from the personal representative to themselves, but they do have to give notice to all of the parties and have a hearing. Number 2 is we have to have a will or a contract from that person who has passed away that expressly authorizes that deed from them as personal representative to themselves. So if you have a will that says that Sally really wanted her daughter to have this piece of property and she gave it to her at the time of her death, that would work and that would solve this second option. Or the third option is you can have all of the interested parties consent to that conveyance from the personal representative to themselves after there has been a fair disclosure. So you do generally need a list of all of those interested parties so we know who needs to sign off on that. But you do have 3 options if you do end up with a deed that is what is classified as self-serving from that personal representative to themselves. Whew, that was a lot. Thanks for sticking with me to the end. I hope you learned some really valuable information today. If you've got any questions about your scenario or general questions, feel free to leave them in the comments below or give me a call or email directly and I'm happy to help. If you're ready to work with us, click the link below to start your order. Thanks for hanging out today. We'll see you soon.